Good afternoon, Priyanka.
Good afternoon, ma'am.
Yeah, is the screen visible? Yes. Priyanka, is the screen visible? You can chat. I hope the screen is visible to you. Priyanka, respond, ma'am. Is the screen visible? Right. Today we are discussing about incorporation of a company and types of what we call documents to be filed at the time of incorporation of a company. Okay. Right. Sure. So actually, this one for the business organization students also there, and I also made for the company law, same topic. Okay, I added some what we call case studies also as per the company law. So under this topic, we are going to learn about what is incorporation of a company and what are the analysis of the procedure to be followed in incorporation of a company, and what is the position of the promoter, and what are the important documents to be submitted. So first, we learn about the introduction and about incorporation, promoter, memorandum, and the articles of association. Yes, companies, whether when we discussed company is an artificial person, right? It's a artificial person being which acts on behalf of owner as a separate legal body, right? So this company, then how do it gets that separate legal existence? With the registration. The registration of a company we call as a incorporation. So generally, this registration, whether it is a public company or a private company, we learned about various types of companies in our previous class. So whether it is a private company or a public company, each company must get uh, existence, should get that legal recognition. They are not, they are supposed to get registration with the Companies Act. Okay, this legal regulation, that is, we learned that is a public limited company means maximum 7 will be there and minimum unlimited. And in case of a private limited company, minimum 2, maximum is 200. And there is, as per the new Companies Act 2013, there is a one-person company also, where one member is a member, one person is the member. Okay, so this company has to start its activities, business activities, or to undertake any of the contracts must get registered prior to that. So this registration of a company we call as an incorporation. Okay, in order to get registered itself with the register of company, the companies has to submit the following documents. Okay, so what are those documents? Memorandum of Association, Articles of Association, and a list of directors who are agreed to act as the directors of company and their written consent, a declaration of the directors, and also a statutory declaration by the company that all the formalities fulfilled. So generally, declaration, whatever the statutory declaration is there, saying that all the provisions of Companies Act has been followed with the in the commencement of business, has to be prepared, and that document has to be signed by an advocate or a Supreme Court of a person or a secretary or a chartered accountant who is going to act as a full-time auditor of the company. Okay, a secretary or a chartered accountant in whole-time practice in India. Okay, so this document which says that has fulfilled all the provisions of Companies Act with regard to the incorporation of a company must be signed. So let us see about, so first incorporation. In detail about these documents we learn in the forthcoming slides. See, so what is incorporation? As per the section 7 of subsection 2 in Companies Act states that registration on the basis of documents, okay, on the basis of documents, whatever memorandum, articles of association, and the information that must be registered, all the documents, and then the registrar will issue a certificate called a certificate of incorporation. Means a company for registration, the Companies Act says, as per the section 2 of subsection 2, says a company must register all the documents required for the incorporation. And after verification of these documents, the registrar will issue a certificate called certificate of incorporation. Both public and private companies must go for this incorporation. But the thing is that, in these documents, any corrections are there. If any documents are not fulfilling the requirements of the Companies Act, then the registrar will ask the company or the members to ratify those corrections and bring a that again back. Okay, but any material defect or anything is there, he will any corrections are required, he will ask to ratify. In any defects are there, and if the company documents are not acceptable by the law, then he will refuse the recognition. So once A certificate of, so after verification and after checking these documents by the registrar, he will issue a certificate of incorporation. And this certificate of incorporation, once a company receives this certificate of incorporation, will a private company can start its business. Why? Because private company raise its capital from the public, so it will not subscribe the public, go for it will not go for the public subscription. Secondly, so it is need not to issue any prospectus. So immediately among the members only it raise the capital. So immediately after the recognition, that is incorporation of a company, a public limited company, sorry, a private company can start its business. But for a public limited company, it need to wait for one more certificate called certificate of commencement of business. Okay, so this certificate of commencement of business, after between the certificate of incorporation and certificate of commencement of business, a company involves some two stages, that is raising of capital. After incorporation and before commencement of business, a public limited company involves with the raising of capital, for which it issues a prospectus, and that will be there for the public. So because the public company raises capital from the public, for which it has to issue the prospectus, and which involves some procedure. And only after raising the required amount of capital, the company can go for starting the business, and that has to be certified again by the registrar. So public limited company has to wait till it get a one more certificate called certificate of commencement of business. So now let us see about these documents in detail. Okay, so memorandum of association, the first one. Yes, this is like this form is like a pillar to the company, like a pillar to a house. To construct a house, how pillar is important. Same way, this memorandum of association is like a pillar, and it communicates about the company to the external world. That means this memorandum of association consists of the information relating to the company, and which is required to be provided by the company to the outsiders dealing with the company. All those details are provided in this memorandum of association. So that is the reason in this they mention the company's powers and its relationship with the outside world. So the purpose of this document is to communicate all the necessary information that is required to be provided to the stakeholders, creditors, and others interested in the company will be provided. Okay. So what are those details? What details the company? See, a company generally as a if a big company is there, what information you expect if a company is coming into is who and what is that company, what's the name of that company, what capital it is coming up with, and who are the members of that company, and where it is located. If we would like to become a shareholder of the company, what is our liability is going to be. Okay, and what is the total capital company, like this. Being an investor, we expect to know these information. So this memorandum of association is a such document which provides all the information that is required by its stakeholders of the company. Okay, that is the reason why we call this as a fundamental document of a company. Okay, and it is a pillar of the pillar. It's like a pillar to the building. Okay, and these information, whatever you're providing in this memorandum, must be prepared very carefully and cautiously, because once prepared, prepared and incorporated with these details, alteration of any of these informations involves huge cost. The alteration on any of the information in the memorandum involves huge cost, that is expensive. So while at the time of preparation of itself only, in the presence of a legal advisor, companies prepare this memorandum of association, because all the information that they provide in these documents enables which builds the relationship with the company, with the outsiders. Okay, So they need to provide. Let us see what is the information. First one is here, as per the Companies Act, definition also given. Memorandum means memorandum of association of a company as originally stated and altered from time to time in pursuance of any previous law of this act. Generally, altered from time to time is not necessarily if required, but not regularly also, not suggested for regularly. So let us see. One of the first step in the formation of a company, memorandum of preparation of memorandum of association is first step in the formation of a company. Next, it set out the constitution of the company. That is what it sets out the relationship of company with its outsiders. The fundamental document of the company. That is the reason why we call them it as a fundamental document of the company. And every structure, the functioning of the entire structure and the functioning of organization is provided in this document. We also call as a basic document or the charter of the company because it is the basic important document. So we also call it as a charter of company, and it is most important document. So this document must be printed. Means whatever the information that you are providing in this document must be in a printed form, not a manuscript. And this, while in providing the information in this document, the information has to be divided into paragraphs, small paragraphs, and every paragraph must be numbered. Okay, so memorandum must be printed, divided into paragraphs, and every paragraph must be numbered. And at the end of the after completion of preparation of memorandum of association must be signed by the directors and the legal and witness. In case of two private company, 2 directors. In case of public company, minimum 7 directors. In case of a 1-person company, 1 has to sign on this memorandum in presence of a witness. Okay. So to be signed by the subscriber in case of 2, in case of subscribers are nothing but directors. Okay. The next, now let us see the information that is provided in the memorandum. Name clause, that is name, situation clause, objective clause, liability clause, capital clause, and general clause. So let us see one of these, each of these clauses. Name clause means under this clause, company specifies name of the organization. In this memorandum, under the name clause, the directors has to mention the complete name of the company by which business is going to be carried on. And this name must follow, means name, the logo or the brand, whatever is there, that has to be specified. Again, while selecting the name, logo and brand of the company, they must follow the names and logos act of the Companies Act. That is, the name of the company or the logo of the company, brand of the company should not be similar with the other existing companies. Whatever the name you select, whatever the brand you select, whatever the logo you select, that should not resemble the similar existing company. So you used to see, I think you may come across of, usually Cadbury's is a very familiar, which is in a cursive writing, 4th style of cursive writing, right? The same Cadbury's font, you will find some other local made also, which deceives. Actually, it is not supposed to be. The Companies Act says the name should not be similar. The should not sound similar, should not match with the existing company name or logos. Okay. The next, if it is a private company, at the end of the company, a term private should be added. Means what you call Suguna Chicken and Private Limited Company, or TMT Private Limited Company. Like that, if a company is a private company, they should suffix a term called private to the company. Company is a public limited company. Simple limited is enough. Please mute. Okay. So company is a private company. It should a private limited, for public company, public organization. So the company should not be registered with such a similar names. It's not the, okay. The next one is, here is private and public. Yes, Emblem and Names Prevention Act also, that your logo, emblem is nothing but your logo should not be similar. That also has to be selected and registered. So name, emblem of official seal of United Nations Organization, World Health Organization, whatever. Those whatever you use, that is official. Okay, this common seal we said, that common seal with the logo of a company usually we take. Okay, that is going to be act as your official signature of your company. So it should not be similar with other ones. The next clause is situation clause. What is situation clause? Which tells about the location and address of where a company is located, the registered, and means the address which has been provided in the memorandum, that is going to be the registered address, and with that address and location the company is going to sue or will be sued in case of legal disputes. Okay, so under the situation clause, company must mention the clear location and address of the organization, the office where it is located, and all the legal disputes or legal related issues will be comes under which jurisdiction, that also they should mention. Based on their location, they should also mention all any future legal issues will be comes under which jurisdiction of that location must be mentioned. Okay, so this address, whatever is going to be specified in this memorandum under this situation clause, is going to be used by the company as its registered address for all its future communications. Okay. The next one is object clause. Objective clause tells about the objectives of a company based on which it is formed. Okay, what it would generally, the objectives of company is classified into three types: primary objectives, secondary objectives, and objectives which are not included in the first two stages. So the primary, I will say for example, if my is a say for example, mine is a textile business. Now my primary objective is provide a trendy and quality material to my customers. The secondary objective, to my primary objective is to reach the topmost position in the textile business. Okay, and my secondary objective is to reach that topmost position in the market, in the textile industry. What I'm aiming for? I'm aiming for providing quality and new designs, providing quality of material to the customers and providing new designs for my customers are my secondary objectives. Then what are the subsidiary objectives, or what are the objectives other than these two? For these two, in order to reach highest position, I need to concentrate on quality product and the quality material and new designs. And these two I'll get only when have a good understanding of the market and proper training to my employees, right? So primary, secondary, and objectives which are not included, like that three types are there. These tells how the company is going to account. Why objectives of company to be doing? Yes, based on your objectives, I'm going to decide whether you are going in the right way, your objectives are achievable or not, and can I invest or not. So a prospective investor will able to decide based on the objectives of a company. Okay. And generally, see, if you go for a certain job also, interviewer asks you why you did a BCom only, why you did MBA only, why you did BA only. So that the answer that you give, if you clearly know the purpose for which you did, you'll able to answer properly. So your confident way of answering enables the interviewer to understand whether you have a purpose to study a particular course or not. Same way here, the object clause tells the stakeholders on what objectives a company is going to work and whether to invest or not. The next one is liability clause. This liability clause of a company tells about the liability of the members. Generally, liability of joint stock companies is two types: liability by limited liability, that is, which is limited by shares, or limited by guarantee. And there are some unlimited liability companies are so there, which tells about what very few. Okay, so under this, the liability clause, company has to mention what is the liability of its members. Is it going to be limited by shares, or it is going to be limited by guarantee? Means the maximum extent of liability to be borne by the shareholder in case of liquidation of a company. That is what specified in this liability clause. The next one is capital clause. Yes, this is again an important clause, which again tells about the capital of a company. What is the amount of capital the company would like to, the total capital of the company expected to raise, and what amount of capital it is raising as of now. And that capital is divided into how many shares, what is the share value, and then how many different types of shares company is issuing. All these details has to be provided, because again, being an investor, I would like to know, because say equity shareholder, sorry, is the one who is a real owner, who has to take the risk, more risk, excuse me, right? But there are preference shareholder who also involves risk, but a lesser risk than the equity. So I'm a risk averse person. I would like to invest in the, I would like to know whether company is offering preference shares or not. That's the reason why, in order to meet different interests of the different investors, a company must specify its total capital, and the capital it's going to issue at present, and then the types of shares, the value of each share, and the terms and conditions of these shareholders and the different types, their rights, everything has to be provided under the capital clause. The next one is association clause or subscription clause. This is the clause which tells about the, which is must as per the law. Under this clause, the directors or the subscribers of the company and the writers of this memorandum of association must give an undertaking that all the clauses in the memorandum have been provided or included as per following the provisions of memorandum. Means a declaration, an undertaking. Yes, we do follow all the provisions of Companies Act while giving in while taking each of the clause in the memorandum. That kind of undertaking. Again, this memorandum must be prepared in writing, in printing. Okay, divided into paragraphs, must be numbered, and must be signed by all the subscribers. Generally 2 in case of private limited company, 7 in case of public limited company, in front of a witness and a legal advisor. Okay, at least one witness. If it is a advocate or a what we call a secretary general, will be more good. Okay, so this why, so that they have been, let's see, you and me are company directors, and you me witness each other, no, not worthy, right? So if third person witnesses that yes, these people has followed all the provisions and they laid all the clauses as per the requirement of law, if third person witnesses, that stands worth, right? So a witness by at least one person must give the witness. That is about memorandum of association. So memorandum of association is a fundamental document. That is the reason we call it as a charter. It consists of 5 clauses. Name clause tells about the name of company. Situation clause tells about the location and the registered address of the company, based on which company is going to do its future communications. And then objective clause, which enables the investors to know upon what the principles company is going to work. The liability clause, the liability of the members, to, so that investors can decide to invest or not. Capital clause, for the prospective information, information to the prospective investors about the capital of company, types of shares, value of share, rights of the various shareholders. These all information, capital clause. Last one, association clause, as per the law, saying an undertaking saying that company provisions of Companies Act has been followed must be signed by the subscribers and the witness. That's about memorandum. Alteration of this memorandum of association involves huge expensive. That's the reason why companies take utmost care while preparing this document. The next document to be submitted at the time of incorporation of a company is Articles of Association. Yes. Okay. So Articles of Association. See, memorandum is for the external world. Means it tells about the relationship of company with the stakeholders. Means outsiders through the memorandum. Means whatever the outsiders who would like to continue, build relationship with the company, whatever the information expects, all that information it gives in the memorandum. Now, for internal management, it needs to lay down certain rules and regulations and certain terms and conditions. So that is placed in the specified in the document called Articles of Association. So Articles of Association is a document in which a company's rules and regulations, terms and conditions for internal management are specified. Is that okay? So this it can, then what kind of contents it consists of? If we look into that, this Articles of Association means company to company. These will be changed. Okay, only the terms and conditions or rules, whatever are there, those are changed, get changed from company to company. Like say, generally, commonly in these Articles of Association, you will find the total 16 to 17 contents. Under each content, the information differs from company to company. Say, for example, first content is name and address of the company. Every company has its own name and address, right? And the next content is the name and addresses of the directors and the position of directors. So again, for every company, there are different directors and different positions, different with different names. The next clause is about what do you call yes, types of shares. What are the different types of shares are there? The rights and duties of these shareholders will be given under the next content. So company to company, these rights given to the shareholders differs. Then calls on shares. Yeah, in your company accounts, you will learn about calls on shares. Means a share value, whatever is there, whichever company collects from the public, that it will not collect at a time. It collects in installments. So those installments, whatever it collects, the share value we call as a call. CAL. We'll name as a call. So this calls on shares means the installments. How many installments company is going to collect the share value and what intervals it is going to collect the share value, that will be specified under that content. So company to company, again it changes. Okay. The next, transfer of shares. It means what are the rights to transfer the shares, and do the shareholders have the right to transfer the shares? If they have, what rights? And if not, why they are not supposed to, right? When they are not supposed to transfer. These details will be given under the transfer of shares. The transmission of shares from one type of shares to other type of transfer. Okay. And the rules and regulations relating to that. The lien on shares. Lien on shares again is another one where company have a different rules and regulations. Forfeiture of shares, that is cancellation of shares in case the shareholder does not turn up the payment on the calls. So when a company can cancel its shares, what are the terms and conditions? What are the rules to be observed? That will be mentioned under the content called forfeiture of shares. Buyback of shares. Again, sometimes company buy back their own shares from the shareholders. So when a company can buy back their shares, what are the terms and conditions? What rules to be observed? This information will be provided under that. Conversion of shares into stock. Similarly, alteration of share capital. If a company wants to alter its share capital, increasing, decreasing, converting, or okay, for increasing different rules or decreasing the capital different rules. So in case of alteration, means change in the capital mentioned in the memorandum, what are the rules to be followed, what terms and conditions are to be applied will be mentioned under the alteration of share capital. Similarly, other managerial persons and their duties, and when company can declare the dividends, matters relating to the dividends, matters relating to the borrowing powers of the directors, matters relating to the accounts and auditing of the books of a company, matters relating to general meetings, directors meetings, capitalization reserves, voting rights of proxies, winding up of company, and audit committee. These all are discussed by the company under each content according to its terms and conditions. Okay, so that is about contents of articles of association. Let us see the difference between the memorandum of association and articles of association. Memorandum of association is said to be a primary document of a company, whereas articles of association is said to be a secondary document of the company. A memorandum of association object is to provide the information that is primary information that is required by the stakeholders. Objective of articles of association is to provide information that is required for the internal management. Okay, or that rules and regulations for internal management. So memorandum is for external, in articles is for internal management. Okay, and the memorandum tells about the relationship of company with the outsiders, and the articles tells about the bylaws and the rules and regulations that will be observed by the internal staff. The status, supreme document, and secondary document, ultra vires. Yes, memorandum. Any act of company which is ultra vires, the memorandum is void and inoperative. Means what? If a company undertakes any act which is not acceptable by, means which is not in the memorandum or against the memorandum, then that is said to be ultra vires. And these ultra vires are not valid. Okay, I'll say ultra vires. You need to use these terms in your answers, being a company law student. Okay, any act of the company which is ultra vires, the memorandum is void and inoperative. The whole body of shareholders cannot ratify it. Means ultra vires means against the term points information provided in the memorandum. So if any act company takes against the information provided in the memorandum, such acts are void, means not valid and cannot be operated. Okay, whereas articles of association, same, but unless otherwise articles permits, same articles of association also ultra vires and void. The next, alteration. Yes, memorandum. See, in memorandum, you're giving your company name, your company address, your objectives, right? If you want to change any of these, what happens? It entirely affects on your business, because based with the memorandum, with some name, you came into existence, you got you identified, and you got popular brand image. And suddenly, if you want to change, it gets difficult. Okay, so there is a cement company which changed its name to Ultra Cement earlier. Can anyone say Kavya and Priyanka? This Ultra Cement earlier it used to be sold with a different name. Okay, then it changed its name into Ultra. Okay, so that change of name is not that easy. It involves huge process again, because it shows impact on the company entire business. So the alteration of any clause in the company memorandum involves needs a special resolution. Means a special minimum 3/4 of members should accept for such change. That is special resolution. Okay, whereas articles of association also need, but for the internal management that won't be that expect. So with a simple special resolution is enough. But for memorandum, special resolution is required, and consent of called consent of the central government is also required. Okay, so that is about our incorporation of a company, and that the two documents to be filed at the time of incorporation of a company. Okay. And now I had to go through her prospectus. So after this, let me go back. Children, do you have any questions regarding these three topics?
No, ma'am.
మ్యామ్ యాక్చువల్లీ నాది సబ్జెక్ట్ కాదు మ్యామ్. మ్యామ్ నెక్స్ట్ క్లాస్ ఎప్పుడెప్పుడు ఉన్నాయి మేడం? నిన్న ఈ రోజు ఈ 2 days క్లాసెస్ అని మాకు చెప్పారు, ఆన్లైన్ క్లాసెస్. మళ్ళీ నెక్స్ట్ సండే ఉంటుందా మ్యామ్? ఓకే మ్యామ్, మీరు ఇంతకు ముందు ఆఫ్లైన్ క్లాసెస్ ఖైరతాబాద్ లో కాస్ట్ అకౌంటింగ్ చెప్పారంట మ్యామ్. మా ఫ్రెండ్స్ వచ్చారు. నెక్స్ట్ సండే మీ మదర్ హెల్త్ బాగాలేదని చెప్పి మీరు రాలేదు. నెక్స్ట్ వేరే మేడం, రాజలక్ష్మి మేడం చెప్పారు.
సారీ, నో, నాట్ మీ. దెన్
అంటే ఫస్ట్ సండే మీరే చెప్పారు కదా మ్యామ్ కాస్ట్ అకౌంట్ కి.
ఈ సెషన్ లోనా?
యా, ఆన్లైన్ కి కాదు మ్యామ్, ఆఫ్లైన్ క్లాసెస్.
నో డియర్, నో.
ఖైరతాబాద్ లో మ్యామ్.
నో, నాట్ మీ.
ఓకే ఓకే మ్యామ్, మీరు ఇన్కమ్ ట్యాక్స్, కాస్ట్ అకౌంటింగ్ చెప్తారా? ఓన్లీ ఈ Commerce-12 ఏనా మ్యామ్?
Actually, this session I have been allotted only this.
Okay.
See children, incorporation of a company is one of the stage in a formation of a company, which has to be done by both public and private limited companies, right? So in this at this incorporation, what is incorporation? Registration of a company. So for registering the company, these companies, both public and private companies, are supposed to get a submit certain documents. In that, one important one is memorandum, about which we discussed now. The next important is articles of association, we discussed it now. Along with these two, a company also should submit a list of directors with the consent of them that they agree to act as the directors of the company. Okay, that means whoever the directors are there, 7, 10 or whatever, and they all should their name, designation, and what must be written, and their consent, written consent, and personal undertaking must be given, saying that they agree to act as the directors of a company. Okay, that the one document. The next fourth document is a declaration that stating that all the requirements of Companies Act, that is like statutory declaration, that while preparing this memorandum or the other documents for the incorporation purpose, whatever the provisions of Companies Act are there, all those have been followed and fulfilled. So 1, 2, 3, 4. These 4 documents has to be signed by the subscribers of the company, and an advocate and a secretary. And these documents, along with these documents, after their signatures, will be submitted to the Register of Companies Act. Then the Register of Companies Act will go through these documents, and if any corrections are there, he will give those for the corrections. And okay, yes, if any corrections are there, you will give those. If any other than the corrections, if they are not as per the Companies Act or not as per the requirement of the law, he will refuse to give the registration. Okay, so once this registrar is satisfied after verification, he will enter the name of the company in a book called Register of Companies. Okay, and then issue a certificate called Certificate of Incorporation. Once companies receive this Certificate of Incorporation, a private company will start their business, but the public limited company wait for one more certificate called Certificate of Commencement of Business. That's about our what you call this incorporation and important documents. Then now let us see. So once incorporation is done, private company go for commencement or start raising their capital among themselves and go starting their business. But your public company needs to get a one more certificate called commencement of business. That is, I'll share one more. So after incorporation, a public company has to raise its capital, right? How it raises its capital? It raises its capital from the public. So to raise the capital from the public, how it raises? How do I know that a particular company wants to raise their capital, right? So what company do? It issue a prospectus. Okay, a prospectus. Through that prospectus, it invites the public to subscribe its shares and raise the capital. But this prospectus, one second. Sorry, one second, children. Why is the option? Right. So through this prospectus, companies rise to raise its capital. Okay, this capital, so what information that company provide in this prospectus, and what are the terms and conditions, or what if not prospectus, what they do, we'll learn under the prospectus. Yes, this is a document. I hope this is visible to you all. So company prospectus, you all might have come across. See, when you want to take an admission in this BRAU in a graduation, when you approach your study center, what you got, children? Did you receive the prospectus or not? Did you?
Yes, ma'am.
You received the prospectus. So what you noticed in that? Have you gone through?
Information about all courses.
Yeah, exactly. Very good. So in that prospectus, university has provided you the university name, registration, and where it is located, and who are the various people in the university. Then courses available, the course duration, and syllabus, examination patterns, eligibility patterns, fees, examination fee, all these details are given in that, right? Similarly, a company, when especially publicly, we are talking about public limited company, a company which wants to raise its capital from the public will issue this prospectus with all information that is required by the investor to know about the company before investing his savings in the company in the form of shares. So a prospectus is an invitation to public where company invites, through which company invites the public to invest, to subscribe their shares in the company, subscribe their shares or debentures. Okay. So prospectus is an invitation issued by a company to the prospective investors, inviting them to subscribe the shares or debentures of a company. Okay, so this is as per the Companies Act, Section 2 of 70, 2013. Okay, any document described or issued as a prospectus includes any notice, circular, advertisement, or the document invitation. You might have noticed, observed recently many companies coming with the IPO, means prospectus, raising their capitals. Many startups, Byju's raised, later on Upstocks raised their capital from public by issue of prospectus. So this document contains all the information that is required. It is called as once this, again this document also must be in writing, and it must be in the form of an invitation to subscribe for their shares. It must be dated. Okay, a date on which prospectus is issued is important. I think I did properly arranged some. Okay. So date of publication of prospectus is important. Why? Because listen. Why? Because from the date of issue of prospectus, within 90 days, 90 days, 120 days, a company must be able to raise its minimum subscription. If it is not able to raise its minimum subscription before commencement of business itself only, company will go into winding up. That is, close it down. So as per the Companies Act rule, a company which issues the prospectus to the public from the date of issue of prospectus within 90 days only. 120 is from incorporation. From incorporation, 120 days. From date of issue of prospectus, 90 days. Company must be able to raise its minimum amount of capital. If not raised, company has to be liquidated before starting the business. So what the companies do in order to avoid such situations, these public limited companies enter into a contract with the underwriters. Who are the underwriters? These are the people who give guarantee of buying the company shares in case of minimum subscription is not raised. In simple, I'll tell you. You see, you wanted to take a BCom degree. Okay. You regular college, inter college you passed, and in the regular degree colleges you applied, but based on your ranking or say take a PG level is based on your rank. In PG wants to join. I said you wrote, okay, and you have a doubt whether you may get a seat in the college or not based on your ICET rank. So what you did to be on safe side, you also paid fees in the Ambedkar University. Okay. So Ambedkar University here is an underwriter, means it is giving guarantee. Yes, you come to me, I'll give you the admission. Right? Okay. Same way, a company which is not means generally to avoid that situation of not able to raise the capital and winding the business before starting itself only, enter into a contract with the underwriters, and these are the people who will give guarantee of buying the company's shares in case of failure of collecting minimum subscription. Okay, and these underwriters generally insurance companies, banks, and financial institutions. These people act as the underwriters. Now, okay, so these are the process for issue of prospectus. After completing all this process, company will issue this prospectus to the public. Now, what content the company provide? About company, what do you expect? What is the company name? Where it is located? What is its nature of business? Who are the directors? Okay, and what is my liability? How many? What is the total capital company is going to raise? How many types of shares are there? Right? Being an investor, what expect? Company name, location, the people who are in that is directors, and what are their positions, and then what nature of business? Is it a finance business? Is it a manufacturing business? Is it a trading business? That is also important, right? So nature of business, and then what you call capital. Next important is capital. What is the total capital of company? In that total capital, how many types of shares it is divided, and each share what is the value, right? Because you are the risk taker, but I'm the risk averse. So I prefer the preference shares because the risk is less. Okay, so I would like to know different types of shares what are there. Next, after that, when the issue, that is when the prospectus, when the issue of shares takes place, and when it is going to close. The first beginning, the opening date and closing date, like your exam fees and admission fee dates, right? Admissions open from, admissions close date. Same way here also, opening date and closing date of issue. And then underwriters, who are the that also enables our investor to estimate the ability of a company. Okay, so underwriters, like colleges used to mention NAC A grade, NAC B grade. That based on that you will estimate the level of the college, right? Status of the same way here also. And then allotment. After I apply for your company shares, now the question is that because so many public may come, but company cannot give shares to everyone because it has limited shares. So now how do it, what is the procedure it allot? Follows to allot the shares. That also has to be given. Okay. And then what is the amount of capital to be raised by a company? Details of the transfer or transmission of shares. The dividend policy of the company. Dividend is the return paid by the company on the shares to the shareholders out of the profits. Company వచ్చిన profits లో నుంచి shareholders కి pay చేసేటువంటి returns ని dividend అంటాం అన్నమాట. It's a declaration of export. This all information has to be given in the prospectus. So this, based on this information, that the the investor will decide whether to proceed to invest in the company or not. Okay, that's about prospectus. Now I said it is must for a company, public limited company, right? Sometimes public limited companies also does not invite the public to subscribe their shares. They also wants to raise their capital among the members itself only. But for the public company, it is important to raise its capital from the means to issue the prospectus. Issue of prospectus is must for public company. But there are certain public companies which do not go to raise their capital from the public. In such case, those companies will prepare a statement called statement in lieu of prospectus. What does it mean? In lieu means in the place of prospectus, they'll prepare a statement. That is called as statement in lieu of prospectus, which contains all the details of the. If a company which would like to prepare a statement in lieu of prospectus must issue at least 3 days before the first allotment of the shares and debentures and must get registered. Okay. And who are the directors that proposed to for that? That also has to be signed. The last. So this is at the third stage for the public company. First stage is, or third stage, not second stage. First stage is incorporation, which both will go. Second stage for the public limited company is raising of capital. To raise that capital, company will go for issue of prospectus. Okay. So once the capital is raised, this prospectus is issued, minimum subscription collected, all the procedure for raising of capital is completed. And this raising of capital procedure and recording process, you will learn under the company accounts, practical aspect. When company issue the shares to the public, how do they allot and how do they collect and what are the installments, how do they record that in the books, you will learn under the company accounts under issue of shares. That is different. So once this issue raising of capital through issue of prospectus is over, then third stage for the public company is to obtain a commencement of business certificate. Only after obtaining this certificate, company can go for starting the business. That is the reason why they go after raising the capital, company, the public limited companies go for raising obtaining the certificate of commencement of business. To get this certificate, a company must provide the documents. Okay, what are the documents? First document that saying that minimum subscription has been collected. Second document, at the time of incorporation, whoever the directors given their written consent, their undertaking that they purchased the company shares. And third document, a statutory declaration that all the provisions of Companies Act have been followed and fulfilled. These 3 documents, remember, for getting certificate of commencement of business, 3 documents to be submitted. 1, a document stating that minimum subscription has been collected. Second, and with the proofs. Second document, that is that whoever the directors given their written consent to buy and act as the directors of company, those directors should say that the company shares has been purchased. Okay. And the third document is a statutory document stating that all the provisions of Companies Act for the commencement of business has been followed. That is statutory declaration. With these three documents in a printed form signed by the subscribers of a company and an advocate must be submitted to the Registrar of Companies Act companies. And then the registrar will go through this document, and after his verification, if he satisfies, he will enter the company's name in a register of public limited companies. Then companies, he'll issue a certificate called Certificate of Commencement of Business. With this certificate, companies gets a public limited company can start its business. Generally, this obtaining this certificate of commencement of business must be done within 180 days of incorporation. That means how many days? Within 6 months. After incorporation, within 180 days, a company should go for getting commencement of certificate. It is not that the certificate incorporation came, I'll go leisurely. Within 6 months, you should also go for complete raising of capital and going for getting the certificate of commencement of business. So within 180 days of obtaining the incorporation, company should get commencement certificate. If a company fails to do so, then it is liable to pay the penalty. Okay, so that's about a statement in lieu of prospectus, statement in lieu of prospectus, and certificate of commencement of business. So public limited company, 3 stages in the formation. Okay, for private limited company, only one, that is immediately incorporation. So first block is over with these 2 classes for us. Do you have any doubts, children? Do you have any doubts?
No, ma'am.
Yeah, I forgot to take a share. Okay. Okay. In the next week, again, we'll have one more class. On that day, we'll start with our what you call the second block, which is about, I think, directors. I'll show the screen. Second block is about management of companies, directors, and types of directors, their positions, and corporate governance. We're going to learn about it in our second next class. Probably next Sunday we may have. Do you have any doubts? Shall I?
Ma'am, any Sundays ఉన్నాయి ma'am classes, online classes?
Usually you will get, actually we also didn't get any schedule. Usually we used to get maybe 8 classes, 6 to 8 classes.
Ma'am, ఈ సండే నుంచి స్టార్ట్ అయినా మ్యామ్ క్లాస్?
Yes, yesterday is the first class and today is the second class.
మ్యామ్ నెక్స్ట్ సాటర్డే సండే ఉంటుందా, ఓన్లీ సండే ఉంటుందా మ్యామ్ క్లాస్?
Next day?
అంటే నెక్స్ట్ వీక్ మ్యామ్, నెక్స్ట్ వీక్.
Sunday, probably Sunday. Saturday is a working day. This is yesterday is second Saturday, so we got what you call 2 days class this week.
సెకండ్ సాటర్డే ఉన్నప్పుడు మాత్రమే సాటర్డే సండే ఉంటుంది, రిమైనింగ్ అంతా సండేసే ఉంటుంది.
Usually, because you will get, I think you will get the schedule also, right? To your
మాకు ఇచ్చిన దాంట్లో సాటర్డే సండే 2 days అన్నట్టుగా ఉంది మ్యామ్. అది మెయిన్ ప్రాబ్లం. అండ్ మాకు లింక్స్ కూడా
సాటర్డే సండే
ఎవ్రీ అని లేదు మ్యామ్, ఓన్లీ 10th and 11th అని చెప్పేసి ఇచ్చారు డేట్స్, 2 dates ఇచ్చారు అంతే.
Maybe they will schedule. Actually, we get a complete schedule. Like your 5th sem means 1 and 3, 2, 4, you got the complete schedule of classes, right? Those are also online classes.
ma'am.
So same way you will get, maybe this time due to some technical issues might be there, so you may not get, you will get the information.
యాక్చువల్లీ మ్యామ్ మాకు ఐడీస్ అండ్ పాస్కోడ్స్ కూడా వేరేవి ఇచ్చారు. అది నేను నిన్న మొత్తం లాగిన్ అయి కూర్చున్న ఒక్క క్లాస్ కూడా అవ్వలేదు మ్యామ్. సో అందుకని కావ్య ఈ ప్రియాంక అమ్మాయిని
Check once again clearly because others joined na.
అది ఇప్పుడు నేను యూట్యూబ్ లో చూస్తుంటే ప్రియాంక వింటుంది. సో ప్రియాంక అని అడుగుతున్నారు సార్ వాళ్ళు కూడా. అందుకని తినని మళ్ళీ గ్రూప్ లో ప్రియాంక ఎవరని తెలుసుకొని తనని అడిగితే తను మీ ఐడి అండ్ పాస్వర్డ్ పెట్టింది. అది కూడా ఇది నా సబ్జెక్ట్ కూడా కాదు, కంపెనీస్ ఆఫ్ లా. అది ఇన్కమ్ ట్యాక్స్, ఇండైరెక్ట్ ట్యాక్స్, బిజినెస్ కమ్యూనికేషన్, కాస్ట్ అకౌంటింగ్. అసలు అర్థం కావట్లేదు మ్యామ్, వాళ్ళు ఇచ్చిన లింక్స్ ఐడీస్ వేరు.
Other group, not this. Commerce 50 semester only, but different group, right?
అవును మ్యామ్.
But actually they send clearly. Last time we didn't heard of these all problems from the students, and they used to attend many number also. A very good number they used to attend. If you have any issues, you can call to the student center, service center.
Okay ma'am.
They will be available. Okay.
Okay ma'am. Thank you.
Right, children. Right, ma'am. Thank you, children. Thank you for being here.
Thank you ma'am.